April Preyar is a criminal defense attorney who has been following this case alongside us since the very beginning, and she is joining us once again tonight. April, first of all, your reaction to this verdict today.
I am not surprised. I must say I'm disappointed because, again, I don't think that this was a typical self-defense claim. I think that the interaction between Mr. Rittenhouse and Mr. Rosenbaum was so unequal in terms of power dynamics that there's no way that this could have been self-defense. In fact, it was murder. But the jury came to a different conclusion, obviously.
How could they? I mean, did they know something, see something that we didn't as we watched this trial on television?
No, I don't think they saw anything or knew anything different than the general public. I think there was a teen boy in front of them who they didn't want to send to prison for the rest of his life. I think that there were racial dynamics in play, and that helped them make their decision, and they just pretty much were hell-bent on not sending a then 17-year-old boy, now 18-year-old man, away for the rest of his life.
Do you think a jury in this case is going to talk afterwards, share their experience and what led to their decision?
I don't know. Like I mentioned before, every jury has their own culture. So some jurors get very close during a short period of time. They stay in touch afterwards. Others want nothing to do with one another. They want to disassociate themselves from this experience and go on with their lives. So I don't know what the culture of this jury is.
I want to play a soundbite from the defense attorney today for Kyle Rittenhouse. He's talking about the decision to put Rittenhouse on the stand. Let's listen to this and then we'll talk about it.
You want the truth?
Yes.
Had to put him on. It wasn't a close call. At certain points, we wondered whether we would put him on. We had a mock jury, and we did two different juries, one with him testifying, one without him testifying. It was substantially better when he testified, I mean, to a marked degree, and that sealed it. But in Wisconsin, if you don't put a client on the stand, you're going to lose, period.
April, was putting Rittenhouse on the stand in his own defense pivotal for the defense in this case?
It was, but I want to clarify something. He kept saying that they made the decision. They didn't make the decision. The defendant has a constitutional right to testify or not to testify. Kyle Rittenhouse made the decision, of course, with his team advising him, but it wasn't the attorney's call. It was his call. But yes, I do think it was the right decision. It was a pivotal moment. The attorney who spoke is correct. Jurors want to hear from the person who's on trial. It could be a misdemeanor theft case. They want to hear what it is you saw, what you thought, what were you doing, why did you make these decisions, why are you justified in those decisions? And because I have to give it to him, Kyle Rittenhouse testified expertly. He was very, very good on the stand. Most people, whether they're 14 or 40, fumble on the stand. They can't get their words together. They can't get their thoughts together. Unless you are a police officer who testifies hundreds of times, or you are an expert doctor who's been on the stand dozens of times, the average citizen never has to take the stand, to have all those eyes on them, to try to keep their thoughts straight, to be able to articulate what it is they saw and they did. So he did a great job, and his defense team obviously worked with him, like they said, for hours and hours and hours to prepare him. So yes, it was a pivotal moment. It was the right choice for their trial, because in a self-defense claim, you have to put on some sort of evidence to back up the self-defense, and the best way to do that is from the person who is saying that they defended themselves, so that you can hear it from their mouth why they did it.
Mm-hmm. And one of the times we spoke right after his testimony, you said you thought those were crocodile tears. Today he cried again when the verdict was read, acquitted on all counts. Do you still think that?
I do, and if you look, I was actually looking at that clip when you played it. There's a difference in body language. I've seen people on the stand who were coached to cry on command, and that's what Kyle Rittenhouse did, in my opinion. But if you notice when the verdict was actually read, it was a release. That he actually was emotionally engaged. He was emotionally drained. Trials are draining whether you're the attorney or the defendant anyway. And so he was drained, and you could see the difference in his body language, that those were real tears as opposed to whatever he displayed on the stand earlier in the week.
If you're his attorney, how would you be advising him to move forward right now? I heard his defense attorney today say, I hope he keeps a low profile.
I would tell him to keep his nose clean, But I think that he's going to enjoy the celebrity. I think he's going to do a talk show tour. I think he'll write a book, whether it's at age 18 or age 21. I think he will eventually write a book. And I wouldn't deter him from doing those things. He has a huge fan base, so why not take advantage of that? I just would hope that he won't put himself in the position to engage in violence again, that he will stay away from all protests of any kind, and that he won't have any more violent acts moving forward.
Let's talk about the bigger picture before I let you go. The term vigilante justice was used many times to describe what happened in Kenosha last year. A jury decided based on the evidence Kyle Rittenhouse acted in self-defense. So what message does this verdict send to the larger society on self-defense, your right to protect yourself?
I think it sends a very dangerous message. Again, I'm going to go back to the instance, the interaction between Rosenbaum and Rittenhouse, because that's the most disturbing, because Rosenbaum was unarmed. So I think what it sends the message is, if you're in a bar fight and you're in a fist fight and you're losing, why not pull out your pistol? If you are in a hand-to-hand combat with somebody, why not use deadly force against that person, even though they're only using their fist? So I do think it's dangerous. And then in terms of vigilantes, I think, yes, it does say, go bear arms in order to police other civilians around you, even though you don't have police power. So I think it sends a very dangerous message. I think we're going to see it play out for years and years in other cases where, whether the name Rittenhouse is actually said in that courtroom or not, it will kind of be the assumption, and attorneys will lean on this case moving forward.
April, thank you, always. Thanks for watching. Click the red subscribe button below so you can get more of NewsNation's fact-driven, unbiased coverage.